Welcome to today's video. First, we will explore how the timing of marriage can drastically change your U.S. family-based immigration timeline. Then, we will unpack the difference between the F1 and F3 categories, explain an optimal path that avoids decades-long delays, and show you how to use the VisaBulletin. Finally, we will summarize key takeaways and include a brief quiz to check your understanding. To guide you smoothly, here is our agenda. First, we define the dilemma. Next, we contrast F1 and F3. Then, we outline the optimal path from F1 to lawful permanent resident to F2A. After that, we show how to use the VisaBulletin. We will then visualize timelines, consider scenarios and pitfalls, take short quizzes, and close with key takeaways. Before we dive in, a quick but important disclaimer. This video is for general educational purposes only and is not legal advice. Immigration rules, processing times, and the VisaBulletin can change. Therefore, you should consult a qualified immigration attorney for advice specific to your case. Now, let's frame the dilemma. An adult, unmarried child of a U.S. citizen is often in the F1 category and may be expecting an immigrant visa relatively soon. However, if that person marries before entering the United States as a permanent resident, their case typically shifts to the F3 category, which is much slower. This unexpected change can add 10 to 20 years to the wait and delay both partners' plans. Let's break down the categories. F1 is for unmarried sons and daughters of U.S. citizens age 21 or older. In many countries, this category progresses substantially faster than F3. F3 is for married sons and daughters of U.S. citizens. The backlog in F3 is often much longer, commonly 10 to 20 additional years compared to F1. Here's the crucial point. If a primary beneficiary in F1 marries before receiving the immigrant visa and entering the United States, they shift to F3. That single change can stall both partners' plans for a very long time. The flowchart illustrates two paths: remaining unmarried and progressing to an immigrant visa under F1, or marrying too soon and moving to F3 with a far longer wait. Once in the United States as a lawful permanent resident, the beneficiary can file for their spouse under F2A, which is significantly faster than F3 in most cases. Quiz time. The question is, if an F1 primary beneficiary marries before their immigrant visa is issued, what typically happens? Option A, they shift to F3, which can add 10 to 20 years to the wait. Option B, nothing changes. They remain in F1. Option C, their spouse is automatically added as a derivative to the current petition. Option D, their case gets expedited due to marriage. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is, they shift to F3, which can add 10 to 20 years to the wait. The reason is that marital status determines the preference category, and marriage before admission as a permanent resident changes the category to F3 with a substantially longer queue. Here is the optimal path. First, remain unmarried until you receive your immigrant visa and are admitted to the United States as a permanent resident. Next, once you hold lawful permanent resident status, file Form I-130 for your spouse under the F2A category. This approach strategically avoids the F3 backlog. While F2A still involves waiting, it is typically far shorter than F3, often in the 3 to 5 year range, though exact times vary by country and policy changes. To put this into action, follow these steps. First, check the VisaBulletin for your priority date and country of chargeability. Second, confirm your current category, whether F1 or F3. Third, if you are in F1 and want the fastest path, do not marry until you have entered the United States as a lawful permanent resident. Fourth, once you are in LPR, file the I-130 for your spouse under F2A. Fifth, monitor the VisaBulletin monthly and review USCIS processing times. Finally, organize civil documents and financial evidence in advance to minimize delays when your spouse's case is ready. Now, let's cover the VisaBulletin. The VisaBulletin is a monthly publication from the Department of State that shows which priority dates are current for each family preference category and country. It enables you to estimate how close you are to visa availability, assess trends, and plan life events accordingly. Because marrying too soon can change your category from F1 to F3, checking the VisaBulletin before making any decisions is essential. This Gantt-style diagram compares two paths. The first path shows remaining unmarried, completing the F1 wait, entering the United States as an LPR, and then filing F2A for the spouse, which typically adds about 3 to 5 years. The second path shows marrying before visa issuance, triggering an F3 category that commonly results in a wait of 10 to 20 or more years. The visualization underscores how the combined F1 plus F2A approach is usually much shorter overall than moving to F3. Let's compare the two strategies. On the left, the F1 to F2A approach requires the primary beneficiary to remain unmarried until they become a permanent resident. After entering the United States as an LPR, they file the I-130 for their spouse under F2A, and the spouse typically waits a few years. This often produces a faster overall reunion. On the right, if the beneficiary marries before visa issuance, the case shifts to F3. The F3 backlog is frequently 10 to 20 years or longer, delaying both partners' plans significantly. The lost time caused by an early marriage is difficult to recover. Here is a fast reference. F1 is for unmarried adult children of U.S. citizens and often moves faster than F3. However, F1 does not allow a spouse as a derivative, because the beneficiary must be unmarried. F3 is for married adult children of U.S. citizens and often involves a 10 to 20 year wait or longer. F2A is used after the beneficiary becomes an LPR. It is for spouses and minor children of permanent residents and often takes about 3 to 5 years. The key risk is that marrying too early shifts an F1 case to F3, dramatically increasing the wait. Let's consider sample scenarios and pitfalls. In scenario A, you expect your F1 case to become current in about a year. If you marry now, your case converts to F3, and the wait may grow by an additional 10 to 20 or more years. In scenario B, you remain unmarried, enter the United States as an LPR, and then file F2A for your spouse, with a more manageable 3 to 5 year wait typical in recent trends. Common pitfalls include assuming marriage does not affect classification, failing to consult the VisaBulletin, misunderstanding derivative eligibility, and delaying the F2A filing after becoming an LPR. To mitigate risk, organize documents early, verify category rules, and monitor the VisaBulletin monthly. Second quiz. The question is, why is the F1 to LPR to F2A path usually faster than marrying early and moving to F3? Option A. Because F2A is typically much faster than F3, reducing the total wait. Option B. Because marriage automatically expedites processing in all categories. Option C. Because F1 allows a spouse as a derivative before LPR entry. Option D. Because the VisaBulletin does not apply to F2As. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is that F2A is typically much faster than F3, which reduces the overall wait. By delaying marriage until after becoming an LPR, you avoid triggering the F3 category and its extended backlog. This decision flow helps you determine whether to marry now or wait. If you are currently in F1 and have not yet been admitted as an LPR, the fastest path is generally to avoid marriage until after entry as a permanent resident, then file F2A. If you are already married or choose to marry before visa issuance, you will fall into or remain in F3 with a longer wait. Both paths should include a reminder to check the VisaBulletin monthly. Here is a quick how-to guide for reading the VisaBulletin. First, identify your category and country of chargeability. Second, find your priority date on your I-130 receipt notice. Third, each month open the new VisaBulletin and locate your category. Fourth, compare your priority date to the posted dates in either the final action dates or dates for filing chart, depending on which is applicable to your situation. Fifth, if your date is earlier than the posted date, you may be current or approaching current. A practical tip is to track movement in a spreadsheet to spot trends over time. To summarize the essentials, marrying before receiving your immigrant visa can shift you from F1 to F3, adding a decade or more to your wait. The faster plan generally is to remain unmarried, enter the United States as an LPR, and then file F2A for your spouse. Always consult the VisaBulletin and consider professional legal advice. Timelines vary by country and can change, so monitor them monthly. In closing, the timing of marriage can drastically impact your immigration journey. F1 generally moves faster than F3, and marrying too early can force a pivot to F3 with a much longer queue. The F1 to LPR to F2A route is often the quickest way to reunite. Use the VisaBulletin as your monthly guide, and plan strategically rather than impulsively. Thank you for watching. If this video clarified your path and could save you years of waiting, please like the video, share it with someone who needs it, and subscribe for more content. In the comments, tell us where you are in the process and what you want covered next. Your engagement helps others find this information and plan wisely.